The staff, which everybody on the staff to some extent participated or contributed to the effort, and I was very proud of them, and I think it gave us a chance to get some recognition for our agency in an event that the community appreciated. I will point out that one of our guest speakers is present. Attorney Israel Reyes was the presenter on the money laundering portion, and did an outstanding job as always, and was very well received. So also I'll point out that we did not lose any money on this. We ran in the black. We had a very good attendance, and there will be some funds left over once we finish paying all the bills from the conference. So all in all, I think it was an excellent event for us, and while I'm not sure whether we will do this particular event again, I'm sure that we will do other conferences, other events in the future, and this experience, I think, has put us in a position to have a much stronger team to put that on. So, unless there are any questions, I will add that I think the city of Miami Police is putting together sort of a highlights video, maybe of the conference, which we'll provide to commissioners, and so you'll have at least a sense of what went on there. All right, as we indicated at the last meeting, we have now hired two new investigators, and we are about to take on a new staff attorney, and I asked them all to be present here so that I could just briefly introduce them. So in case you see them around the hallways, you'll know who they are. We have Robert Steinbeck. Robert has an MS in journalism from Northwestern University, one of the finest journalism programs in the country. He has an BA from the University of Rochester, was a well-known journalist and columnist with the Miami Herald for a number of years, and he's on board, and it began, I think, May 3rd. And Robert, I don't know if you want to just say a word or two, but come on up.
Well, I just want to express my gratitude to Mr. Santorinos and to Mike Morosky, and also to Miriam Ramos for having the faith in me to execute the office and the responsibilities that are handed to me. I'm looking forward to doing it.
As always, thank you.
Thank you.
Welcome aboard. And Larry Leibowitz. Larry also is a journalist by trade, and also graduated from one of the finest journalism programs in the country, Boston University's program, and longtime investigative reporter for Miami Herald. Larry?
Thanks. As Robert said, I'm happy to be here, and really looking forward to doing the work. And the work is important. The work that we're doing here is important for the community. And ultimately, that's what it should be all about. And it's an interesting time. Journalism's in a lot of transition, and so a lot of us are looking at different things to do. And this is a good fit for my skills, and I'm looking forward to it. Thank you for the opportunity.
Thank you. Welcome.
We've also hired a new part-time attorney to help with some of our opinion work, as well as some of our training work. Her name is Gilma Diaz-Greco, and she's here. She is a graduate of the University of Miami and the University of Miami School of Law, and she has a lot of teaching experience, which we found particularly helpful in terms of her capacity of being involved in our various training programs. So I think she knows the answers to the name of Mimi. Am I right? All right.
Good morning. I don't know if this is working. I wanted to say also that it is such a privilege and an honor, and I am so grateful to Mr. Santorino and Ms. Ramos and everyone in the commission for the opportunity to serve. It has been an incredibly smooth process. It has been very quick getting me on, so it's been very impressive, and I think a reflection of how well the agency works. And it's just an honor and a privilege to have the opportunity to work for the commission, both as a person that's serving and as a citizen. I will reflect the comments of my colleagues that it's about the work, and I'm just thrilled to have the opportunity. Thank you very much.
Thank you, and welcome.
Thank you. All right, and the only other matter I wanted to just briefly touch on here is that we have begun our boot camp. The city of Miami Beach, which has essentially entered into an interlocal agreement with this agency to provide rather intensive, I was going to say therapy, I meant to say training. Given some of the special challenges that they've had at Miami Beach, they have a new city manager now, by the way, Jimmy Morales, who, even though he wasn't the one who had arranged for this to occur, he has welcomed us and is very much enthusiastic about our presence there. And last week we did 5 classes of 50 or less of their regulatory employees and giving them an introduction to ethics. We have future classes planned in the ethics code, and we have a former employee who became an inmate of one of our facilities, who is going to participate in this and is going to provide, I think, a perspective that only somebody who has run afoul of the law could provide, and whose career was ruined, but who is as part of this program is going to speak and be involved. It's going to be tailored in many ways to the regulatory employees, being the building inspectors, the code compliance people, the parking enforcement, planning enforcement, and so forth. So it's a very specialized program. I don't think it's ever been done like this before. Each of these people will be given over 12 hours of ethics training in the next few months, I think it's the purpose of it. I think the design of it is to really not just talk about ethics for an hour or two, but really try to change the culture of the organization to some extent. So we'll be reporting for our future sessions, but I just want to give that update. I think everything's going smoothly, and I think we've been very well received there. So that will conclude the ethics director's report.
Thank you. We will now take any public comments. They are limited to 3 minutes per speaker. Okay. Hearing none. We will move to complaints. So we have 4 complaints in open session. 1228, 1231, 1305, and 1241.
Yes. 1228 is we're asking for the commission to sign an order that we can attempt to garnish the paycheck of Mr. Randolph Akins. If you recall, a few months ago, Mr. Akins was here and entered into a settlement agreement, agreed to pay us a $500 fine. He paid half of that, and since then he's been recalcitrant. And so we're going to attempt to garnish the paycheck before we have to try to go through the process of going to swell claims court, which is much more time consuming. So if you'd be willing to sign it on. And actually, on the next case, which I believe is 1231, the respondent and his lawyer are not here yet, so if we can pass over that for the time being, we'll go to the next case.
What? I'm sorry. What number was that?
It's 1231.
1230. Okay.
13005 is the next case. It should be in your main packet. This was the woman, I don't know if you remember from last month, who had not filed her financial disclosure statement after serving on one of the Coral Gables boards. And I had mentioned to you that I had had her personally served and she didn't appear, and later learned that she had newborn twins. So once she got herself together, she called and profusely apologized, immediately filed the form, which I have here. And then I sent her a settlement agreement and said that if you pay cost in the amount of $50, essentially what it's cost us to kind of get her to comply, that we would go ahead and settle the case. And so she's agreed to do so. She doesn't contest the allegation, and she agrees to pay the $50 if you all ratify the settlement agreement.
It would have been retroactive.
We're in public session, so I make that motion to ratify the proposed settlement.
So motion and a second. All in favor?
Aye.
Aye. Any opposed? Motion is adopted. Thank you. Thank you. We have one more.
We have 1241. Mr. Della Gloria is here and Mr. Sarnoff present. John, this is your motion, so
Yes.
I give you the floor.
Good morning, John Della Gloria for the respondents. I know that you have been bombarded, as the word has been used to, bombarded with transcripts and arguments, etc. I'm going to try and keep this very short, which should certainly be a point from my side. There are two concerns. One is whether Mr. Sarnoff was required to file a gift disclosure as to his trip, and second, whether Mrs. Sarnoff's trip constituted a gift that also had to be reported. I'd like to break this down into doing one first, and that's regarding Mr. Sarnoff. As we have said continuously, Mr. Sarnoff sought the advice and received the advice of his city attorney that he did not have to report his trip as a gift. In your letter of instruction, you had voted not to include any language regarding probable cause. The issue, I believe, that Mr. Morawski and I have been kind of battling over is whether at the first hearing, you voted on probable cause. Our position was that you undid that during the course of the future hearings, particularly hearing number 3. Assuming arguendo that your initial vote occurred and was never reversed, we just ask a simple question. Please consider that matter right now as part of your determination as to what the final order will say, and decide whether the sitting commissioner who seeks advice from his city attorney, receives the advice, has not done anything that would cause this commission to say there was probable cause that a violation existed and it occurred. Okay? The only other thing I wanted, well, just two other points. One, and both regard the Miami Beach case. One, you accepted arguments in the Miami Beach case that actions were inadvertent, and there were comments in the Miami Beach transcript that stated and recognized that such a finding would be detrimental to the reputation of the elected official. And you said that in that case, and we believe the same thing has occurred here. We're issuing a letter of instruction. The commissioner will then be on notice. The city attorney will be on notice. That letter, by the way, is going to the city attorney in the Sarnoff trip matter. So I just want to keep it simple. We don't have to rehash a million arguments. That's our position. Again, if you think that you voted that way the first time and never reversed that, we'd ask you to do that now.
You want to talk about the second issue?
Not right now. I would appreciate just separating this and having the first issue taken up, and then I will again make a very short presentation on the second issue.
Good morning. I would just like to thank my friend John Della Gloria for finally being able to crystallize his arguments down to 2 points after going back and forth with quite a substantial amount of motion work. So just addressing that first issue of whether or not there was probable cause regarding Mr. Sarnoff's trip to Brazil, just the trip that he took. November 27th hearing, this commission had a probable cause hearing. You determined that probable cause existed. At some point after that, there was a discussion about how to resolve the case, and I think the agreement was that it would be dismissed with a letter of instruction being issued. Subsequent to that, Mr. Della Gloria stood here and made a request I'd never heard before, where he phrased it in such a way as to delete the words probable cause from the letter of instruction. Now, maybe in his mind, he thought that that meant you were overruling your finding of probable cause. But I certainly didn't think that. I don't think that's what this commission thought he was asking for, because later on in a subsequent hearing, I remember very well Commissioner Melito saying, well, Mr. Della Gloria, it sounds like what you're asking us to do is overrule our finding of probable cause, and I don't remember you ever asking us to do that. And so it was clear to me that was not what Mr. Della Gloria was asking for. Now, here we are 6 months later, and he's coming in and he's saying, please, overrule your initial determination of probable cause, having presented no new evidence, nothing that ought to change your mind, no law or rule that requires you to change your mind. I point out that in his most recent response here, dated May 17th, he says that as a matter of law, he's telling you that as a matter of law, no violation can be found if Mr. Sarnoff relied on the advice of the city attorney.
Can I ask you, I don't know that you have a copy of it in front of you, the proposed rules, procedural rules, 3.7?
Our rules?
Yes. Because I just want to turn your attention to 3.7.
The new ones.
Yes.
We all have.
And I imagine it's the existing, since there's no change indicated. And you can inform me of that fact.
What?
3.7. It says intentional or unintentional violations. I simply want to get some clarity on how that relates to this matter.
Rules of procedure.
Page 11.
Here.
Page 11.
I should have it 1 second. Thank you. Okay, I'm with you.
So as I read that, there seem to be intentional violations and unintentional violations. Unintentional violations are not violations.
They are still violations.
They are still violations.
Correct. Yes.
They are simply different consequences that attach
That's correct.
to intentional violations.
Yes, sir.
So how do help me understand what this means for what we are able to do if I am to file Mr. Sarnoff's actions as an unintentional violation? That is to say, the reliance on mistaken information given by one's city attorney.
Okay, that's an easy question to answer. Because the procedure is, when a complaint gets filed, it goes through a certain process and procedure which is in our enabling ordinance. And the very first step says there has to be a determination made of legal sufficiency. Now, either that complaint is legally sufficient or it's not. And if it's not, it gets dismissed. If it is, it goes to the next stage. And the next stage is the determination of probable cause. And the enabling ordinance says that means you are to determine whether a violation occurred or not. That's all that PC is. Did a violation take place or did it not?
So we are not making a determination about whether or not the violation was intentional or unintentional.
Not at the PC stage. All you're thinking, did a violation occur? You make that determination, you move on to the next stage. The next stage might be a public hearing where we hash it out, or the next stage might be some sort of agreed settlement, or the next stage might be that the commission decides on its own that for whatever reason the violation was so insignificant or insubstantial or inadvertent that we're just going to dismiss the case and issue a letter of instruction saying, don't engage in that kind of behavior again, or you made a mistake, we're putting you on the right path to enlightenment. That's the simple answer to that question, and I think that's what we did in this case, and I think that's what we should do.
If I can add, the intentionality matters at the penalty stage. The penalties are doubled when there's an intentional violation found. That's where the intentionality really comes in.
That's the only distinction.
If I may, I think we're getting a little far afield from what the issue is here, though. The commission does have the prerogative to issue letters of instruction and to put anything it wants in the letter of instruction. I think we're being told that we have to do this or we have to do that. Well, frankly, we don't. We don't have to do anything in terms of probable cause, in terms of not probable cause. We can issue a letter of instruction exactly how we want to do it. We've done it in the past, and we can do it in the future. So that part, I don't want to hear that we have to do this. Second of all, I do believe that it is a slap in the face of every city attorney in this county that if you were to say that one of their clients, a city official, relies on their advice, that there is no protection whatsoever in relying on the advice of your counsel, then I think, to me, it's a huge offense to them. It's an offense to municipalities that have city attorneys, and I think that's problematic. This is a really simple case, okay? The case is that, yes, it happened, and what happened with the advice of counsel, but we're issuing a letter of instruction, and the public will learn from this experience, okay? The fact of, if the order says that there was probable cause found in it or not, is not going to add to the lesson to be learned here, and there's no compelling reason why it needs to say that. Again, in saying that, I think you're taking an affront against city attorneys, number one, and number two, you're adding an element here that's completely unnecessary in this case. We have the prerogative to do what we want and say what we want in a letter of instruction. I'm really tired of seeing this case, and I think we can absolutely done with it and dragging on for way too long.
Mr. Chair, if I could just respond briefly to Commissioner Rosenthal. And I don't want to get into an argument with you, but there's a distinction between the letter of instruction and the final order. Those are two separate pieces of paper. I bring letters of instruction for you to approve, so you can put whatever language you want to put in the letter of instruction. Mr. Della Gloria stood here and said, please take the words probable cause out of the letter of instruction, and I agreed to that. I said, fine, if you don't want those words in that letter, that's fine, because that doesn't affect the finding of probable cause that was made. The finding of probable cause goes in the final order. Then he came back and said, well, I want you to just overrule the probable cause finding altogether. That's what he really wanted, and that's what he argued for, but when you first heard the case, you disagreed with him. The second point that you made is we don't slap anybody in the face. We don't, it's not a slap in the face to a city attorney anywhere to say, well, we're going to find probable cause that a violation occurred. What in fact we're telling them is you gave them the wrong advice, that's why a violation occurred, but we're going to dismiss this case because they relied on your advice, because they reasonably relied on their advice. And we've done that many times, and I've never heard any city attorney come back and say, I'm mad at you because you slapped me down.
Well,
I'm not trying to slap anybody.
I don't think we've ever done this before, number one. And number two, it's the same thing. With regard to final orders, we've had the final orders that had findings of probable cause, that didn't have findings of probable cause. We've had final orders that said a letter of instruction will be issued. And again, there's no, well, there is precedent for us issuing a final order without a finding of probable cause. I mean, we've done it before.
Commissioner Schwartz is next.
Oh, certainly.
And so, again, I don't know why this is so complicated.
Are you finished?
Yes.
Had I been at the November meeting, I would have voted against finding probable cause against Commissioner Sarnoff. There's a commission or a committee, they keep changing the name of it, so I'm not sure what it's called, but that gives advice to judges when judges seek advice on procedural matters. And if the judge relies on the advice of that commission, it's presumed that they acted in good faith in relying on that. If the Supreme Court later determines that the commission was wrong, then the commission can do, or the Supreme Court can do whatever they believe is appropriate. If Commissioner Sarnoff sought and obtained an opinion from the city attorney, and the city attorney gave him advice and he followed that advice, that compounded by the fact that there seemed to have been confusion going on with the full state of the law at that time, would have led me to not vote for a finding or to vote against a finding of probable cause at that time. So I have no problem with not finding probable cause in the final order or in the letter of instruction as it relates to Commissioner Sarnoff's following the city attorney's advice.
Thank you, and just to illustrate the point that Commissioner Rosenthal is making, in the Miami Beach order, which we've talked about ad nauseum, in which I attached to one of my responses, you specifically said you're not making a determination as to whether there's probable cause. You have a range of options, and we would ask you to follow that.
Commissioner Anderson?
Yes, I recall making the finding, coming to the voting on the finding of probable cause, and I guess I'm wondering, under the Right to Information Act, if, I mean, doesn't that become part of public record, which and so don't we have an obligation to have that as part of public record? I would have no problem with also adding in, the term that it was unintentional, because that's, I think, was also, the agreement of the board was that we felt that it was unintentional, because he'd certainly made a good faith effort to find out what would be the ethical thing to do here. So, it's just that as a matter of law, we saw that this was probable cause so that people won't do it again. But certainly we found in his case that it was unintentional, and certainly he was operating in good faith.
The only other thing, I wrote down what Mr. Della Gloria said about, he was talking about the fact that, your findings can be detrimental to people. So just a mere finding of probable cause is going to hurt somebody's reputation. Every single finding you make could be detrimental. Are we now going to have attorneys come up here and say, well, if you find probable cause, it's going to hurt my guy's reputation, therefore you should not find probable cause? I think that's ridiculous. If the facts support probable cause, then there's probable cause, and it's inappropriate to take into consideration what somebody's reputation is.
So I think that, let me certainly, I think that where we were when we last talked about this, I think that at least for some of us, these issues were ventilated, and I think what we were waiting for was simply a full commission to actually sort of vote on this. As I said, when we voted, there were 3 votes in favor of deleting the term probable cause and 2 votes against that. Even though I was opposed to that, I think I remember, at least from my fear, that is to say, the thing that I feared was that the deletion might leave us without precedent, right? But again, I think that what we voted on was a deletion of probable cause in total. And so despite the fact that I would have voted against the original deletion, I think I vote, at least with respect to the integrity of what I think my fellow commissioners voted on, and what I at least think I voted against, at least with respect to Commissioner Song. But I think we are ready now, at least to call the question about the extent of the repeal of the language of probable cause. So if we could have a motion on that.
So, Mr. Chair, is the motion you're talking about, just so I'm clear, is it okay if I ask that? Is the motion going to be to overturn the finding of probable cause from November 26th?
I think the motion would be to reaffirm what...
Okay, I'm going to make a motion that's neither overturning or turning or anything else. I would make a motion to have a final order in this case, to issue a letter of instruction, and without stating that there was probable cause in the final order. That's simply to issue a final order directing that with regard to this case, a letter of instruction is being issued.
Second.
Can I just ask again, I mean, if we don't put the words probable cause in the final order, but there was a finding of probable cause that was made, does that still exist somewhere in the cloud?
It exists. In reality, what happened, and there's no necessity. As I said, we've done final orders before also. It's not critical to a final order to put whether a determination of probable cause was had or not. In this particular case, I think we've discussed the circumstances numerous times, and I've made my position.
I think it's critical to put in the final order what the action of the tribunal was. And if the action of the tribunal was that we found probable cause, then that should be in the final order.
This is outrageous.
Again, I don't think it is, and we have precedent for not doing that.
What part becomes part of public record?
Every
file.
Everything.
The entire file.
It's already there.
So it's already there as far as our vote.
Is that correct, Mr. Morris?
That-
It's already there. I mean, the probable cause was.
Including
the minutes.
We did determine probable cause. I mean, let's be very clear.
Yes, you did.
We
Yes,
made
you did.
that determination.
Yes,
I
you
think Commissioner Addy's position regarding an explanation is in order. He relied on the city attorney.
Okay.
We all make that very
You
clear.
wanna
It's
put
part
that
of our